So my name is Brian Kahn. I work for the enforcement division at the FAA. I work for the Midwest enforcement team. However, I'm physically located at our headquarters office. The enforcement division is made up of roughly 40 attorneys nationwide. We have attorneys in Boston, New York, Atlanta, Fort Worth, Chicago, Anchorage, Alaska, Seattle, and Los Angeles. We do primarily certificate actions, civil penalties against businesses and airlines, etc. But with regard to certificate actions, I'll be talking about the compliance philosophy. And typically before compliance philosophy existed, compliance to the FAA meant suspending your certificate as a means to accomplish that. However, now we've changed the philosophy, and so we want to promote the highest level of safety and compliance. We do that, or we want to do that because the most effective means for a person to return to full compliance. We want to promote an open problem-solving approach to allow safety problems to be understood through the proactive exchange of information. It allows for the use of a less stringent means to gain compliance when the person is willing and able to take corrective actions. And we'll get back to the willing and able part in a moment. It also identifies intentional or reckless behavior as the highest risk to safe operations and will require enforcement. So a couple years ago, or a few years back, some of our cases would be 30-day suspensions or 45-day suspensions for a TFR violation or altitude deviations. If you don't do those intentionally under compliance philosophy, typically we'll handle it now via education or remedial training or counseling. So that's our new compliance attitude, and it seems to be working, as you'll find out in a moment. So previous to compliance philosophy, the FAA focused on enforcement and gathering items of proof. Enforcement was the primary means of ensuring regulatory compliance. The action was taken largely on outcome or potential outcome. So compliance action will be taken unless the determination has been made that a compliance action is not appropriate. We focus on corrective action that properly addresses risks. Our emphasis is on voluntary compliance, information exchange, and use of safety management principles. And actions are taken based on the underlying behavior or behaviors. So this is what Administrator Michael Huerta said with regard to compliance philosophy. He said compliance philosophy is the latest step in the evolution of how we work with those we regulate. It focuses on the most fundamental goal: find problems in the national airspace system before they result in an incident or accident. Use the most appropriate tools to fix those problems and monitor the situation to ensure that they stay fixed. So when the FAA, let's just say you have an altitude deviation and the FAA contacts you, the inspectors must remain engaged with you, with the responsible person to conduct a thorough investigation. FAA personnel will gather facts, ask questions, and analyze events to determine if there is compliance. This is where the information from the person involved is valuable and will be used in the determination of the necessary corrective action. The correspondence from the FAA concerning a compliance action should contain a statement that the event appears eligible for a compliance action, a statement that enforcement is not being pursued based on the known information so far. For compliance actions, the FAA will provide a brochure that explains the compliance philosophy and the Pilot Bill of Rights. I'm sure you've all seen it. Looks like this. It has all the information inside: your rights, what the compliance philosophy is, our hope that we can work together to figure out an action that will result in a safer airspace. So the brochure will be provided during initial contacts with an airman involved in a potential deviation. It provides overview of the compliance philosophy, and it explains your rights to obtain legal counsel and to request air traffic data. Refusal to speak with an FAA inspector immediately after an event or obtaining legal counsel does not rule out compliance philosophy. Airmen and organizations are free to exercise their rights without repercussions. And an entity that complies with FAA requirements to regain and maintain compliance is considered cooperative. However, if FAA personnel cannot adequately determine the facts of the case or cannot identify appropriate remediations that are consented to, FAA personnel must still use due diligence for public safety interest. Such due diligence may include re-examination or suspension pending compliance to determine that the certificated entity is qualified, competent, and proficient. So in other words, while it's your right not to speak with us, if we can't adequately determine the facts of the case or appropriate remediations, we'll have really no choice but to pursue some sort of other enforcement action as opposed to compliance philosophy. So actions not eligible for compliance action include intentional or reckless deviations, if you're unwilling or unable to comply, certain matters involving lack of qualification. So that lack of qualification, testing positive for drugs or falsifying documents that we rely upon. That would be examples of a lack of qualification. If enforcement is required by regulation or law, failure to complete corrective action, and repeated noncompliance, which is kind of a discretionary function of the inspector. If you have like one deviation and then you had one before, maybe like 3 or 4 years back, that probably wouldn't be considered repeated noncompliance. So for deviations resulting from flawed procedures, simple mistakes, lack of understanding, or diminished skills, some of the remedies would be on-the-spot corrections, additional training, and counseling. A compliance action does not constitute a finding or violation. The FAA may also consider corrective actions already taken by the airmen when determining the appropriate response to the problem. Airmen are encouraged to take proactive steps to identify and address known safety issues. So like I was stating earlier, the individual must be able and willing. So with regard to able, they must possess time and resources to correct the deviation, and they must have the ability to meet standards after taking corrective action. With regard to being willing, typically those signs are you acknowledge responsibility for what happened, you share information to help determine the cause, and you promptly implement corrective action. So these are some statistics from 2016, fiscal year 2016. The FAA took over 5,400 compliance actions, and these represent risks that were identified, documented, and addressed without enforcement. So with regard to legal actions, we had approximately 750, which is a roughly 55% reduction prior to compliance philosophy, and administrative actions decreased by 75% compared to fiscal year 15 or before compliance philosophy. So similar trends are being seen for this year, and yeah, we're pretty happy about that.
Can you give us an example of legal action?
Just a second here. We're recording it, so that way they'll be able to hear it at home.
I wondered if you could give an example of legal action.
Well, a legal action could be anything from an intentional act, so something that wasn't eligible for compliance action. So it would be, let's say you are landing in an airport and air traffic tells you to go around, and you say, no, I'm not going to go around and land. That would be an intentional violation of the Federal Aviation Regulations, and that probably would result in a suspension, and that would be a legal action. Or if you falsify a medical application, say you have a DUI and you got arrested and convicted, and 18V says, have you ever in your life been arrested for, an alcohol-related event, and you check no, that would result in a legal action as well. So with regard to compliance actions, the average time to complete a compliance action was just under 4 weeks. This is a dramatic improvement over time spent closing an enforcement action, which traditionally could take more months or years. So just an idea of how prior to the compliance philosophy, a case would come to our attention. we'd have to send a letter of investigation, we get a letter of response. We'd put together all of our items of proof. By the time you got the letter or the notice of proposed certificate action, could be upwards of 6 months have passed since the incident. So a dramatic improvement in addressing the situation. And current trends indicate that enforcement action initiated in fiscal years 16 and 17 are also being adjudicated faster compared to previous years. So I'm just briefly going to talk about unmanned aircraft systems. The operating requirements under Part 107, the UAS has to be under 55 pounds. The operation must be in visual line of sight. If you're going to use first-person view, you must have a visual observer. You can only fly during daylight or in twilight, which is twilight is 30 minutes before official sunrise to 30 minutes after official sunset. You cannot fly a small UAS over anyone not participating in the operation. Operations in Class G airspace are allowed without air traffic permission. However, you must have air traffic approval to operate in Class B, C, D, and E airspaces. You cannot operate over 400 feet AGL and over 100 miles per hour. However, there are waivers. That waives most operational restrictions if you can show that your proposed operation can be conducted safely under the waiver. You must be certificated, a remote pilot airman certificate with a small UAS rating. To qualify for that, you have to be at least 16 years old, pass an initial aeronautical knowledge test at an FAA-approved knowledge testing center, or if you already have a Part 61 certificate, other than a student pilot certificate, you must have completed a flight review in the previous 24 months and must take a small UAS online training course provided by the FAA. The FAA does not require small UAS to comply with current airworthiness standards or aircraft certification, but however, you instead have to perform a pre-flight visual and operational check. The UAS must be registered, and this is only for Part 107 operations. The case that everyone heard about, Taylor versus FAA, where they said, your aircraft, your UAS doesn't have to be registered. That doesn't affect the registration required for Part 107 operations. That was strictly for UASs operating under the Section 336 exemption, which is the model aircraft exemption. So you're exempt from the rules of Part 107, including the registration requirement, if the aircraft is flown strictly for hobby or recreational use. The aircraft is being operated in accordance with a community-based set of guidelines and within the programming of a nationwide community-based organization. The aircraft is generally limited to not more than 55 pounds, and the aircraft is operated in a manner that does not interfere with and gives way to any manned aircraft. And when flown within 5 miles of an airport, the operator of the aircraft provides the airport operator and the airport air traffic control tower with prior notice of operation. Oh, go ahead.
Yeah, I'm not familiar with Part 107, but the exemption, does that mean that you don't have to have a certificate?
Correct.
You don't have to be licensed?
Yeah, correct. So if you're operating under the exemption, unless you do something careless or reckless, or if you operate outside of those parameters, then you're subject to 107 regulations. So let's just say that you are, you're flying for hobby or recreation, or you think you're flying for hobby or recreation, and then you take it up to like 7,000 feet, which has happened.
Sure, stay below 400.
Yeah, so then you'd be subject to all the Part 107 regulations, including the registration requirement, the pilot certificate requirement. But if you stay within the parameters of hobby or recreation and Section 336, then you're not subject to Part 107.
Just take it out of the box and fly it.
And a couple other things before if you have any questions. There's a couple other topics I didn't put on slides, but another hot topic actually is, as I'm sure everyone knows, is that marijuana has been legalized in many states. However, it still remains a Schedule I drug, and it's still subject to drug testing, and you obviously can't use marijuana and fly even if it's legal in a state. Even if it's in your system, you still can't do it. And that's one thing, you know, people don't understand that, you know, but it's still a Schedule 1 drug, and the federal aviation regulations do not allow for use of that drug. So with that, are there any questions that I can answer? Go ahead.
They reschedule it, how would it go? If it gets rescheduled from Schedule 1, how would that work for medical?
Rescheduled to what, though? Because
Schedule 2.
Well, Schedule 2 drugs, those include still amphetamines, anything that has any sort of medical, I guess.
Schedule 3.
Schedule 3, I'm not sure.
Oxycodone or something like that. I mean, under medical rules. So, for instance, like Los Angeles, Proposition 215, now legalization of Proposition 64. Like, how would that work for medical patients if it gets stepped down federally once states go 2/3? That's what I'm asking.
Yeah, I'm not sure. You could maybe ask our medical folks in the hangar about that. And
Okay, cool. Thank you.
Are there any other questions? Even topics I haven't covered, I can try to answer them. Well, thank you very much for listening, and hope you guys had a good week so far. And yeah, enjoy the rest of the day.